Good morning, Mr. Nicholson. Good morning, everybody.
Good morning, DCJ.
Are you ready?
I am ready, Chair.
Yes, okay, let's start.
Chair, the witness that will be testifying today is Advocate Cyril Simphiwe Mlotshwa. He is the former acting DPP of the province of KwaZulu Natal. He's now a member of the Pietermaritzburg Bar. Advocate Mlotshwa will deal with his involvement in the Cato Manor prosecution and primarily and other related issues of the NPA. With the leaves, Chair, may the witness be sworn in.
Thank you. Please administer the oath or affirmation.
Please state your full names for the record.
Cyril Simphiwe Mlotshwa.
Do you have any objection to taking the prescribed oath?
None?
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you'll give will be the truth, the whole truth and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Chair, there is a bundle prepared for the Chair. The bundle has been marked Exhibits RR6. With the Chair's leave, may that bundle be handed in?
The affidavit of Mr. Cyril Simphiwe Mlotshwa, deposed to on the 9th of December 2019, together with its annexures, is admitted and will be marked as Exhibit RR6.
I'm indebted, Chair. Mr. Mlotshwa, can you have a look at the bundle before you at pages 1 and 2?
Yes.
Are you able to identify that document?
Yes, it is a confirmatory affidavit that I deposed to in December 2019.
Okay. The signature on the second page, is that yours?
Absolutely.
And the signature and the initials?
That is,
That's correct.
And the deponent?
there are two signatures on page 2. So the one above deponent is yours.
That is correct, Chairperson.
And the second signature, is that the signature of the Commissioner of Oaths?
That is the position.
On page 1, there are 2 sets of initials. Whose initials are those?
The first one will be mine on your left.
And the second one?
The second one will be that of a Commissioner of Oaths who administered the oath to me.
Okay. Now this affidavit at pages 1 and 2 confirms an affidavit which is at pages 4 and 5, is that correct?
That is correct, sir.
Are you the deponent of that affidavit at pages 4 and 5?
Absolutely.
And the initials at the bottom, right hand, are those your initials? And
Yes, initial CSM, yes, mine.
and on the left-hand side, are those the Commissioner of Oaths?
That is the position.
And then at page 5, we have a full signature above what is typed out CS Mlotshwa. Is that your signature?
That is correct, sir.
And the signature below that is that of the Commissioner of Oaths.
That is the position.
Okay. At page 6, we have another affidavit. Can you confirm? Do you identify these documents? Let me put it that way.
Sir, the position is, if one meticulously looks at the affidavit that you have referred to on page 4 and 5, it makes reference to emails that were exchanged. So as I deposed to that affidavit on 12 May 2015, I was a few months in July approached by the same Commissioner of Oaths requesting me to hand to him the emails that I had referred to in the initial email. So it's just an affidavit that was confirming the handing over of those emails to the investigating officer at the time. I think he was Colonel Daue.
And at pages 7 to 12, are those the emails you're referring to?
That is the position, sir.
Okay. Now, at pages 40 to 67 of the bundle, can you identify that document?
Yes, I think this will relate to the evidence that I tendered before the Mohoro Commission of Inquiry in respect of two NPA senior officials.
Is the correct name Justice Mohoro Inquiry?
I confirm that, sir.
And did you testify on the 1st of February 2019?
That is correct.
Does your testimony go from page 14 to page 67 of the bundle?
Well,
That is also true.
that's on 15, isn't it? Page 14 is just the covering page.
That is correct. Does your testimony go from page 15 to page 67 of the bundle?
Yes, my apologies. Chairperson, it seems it goes further than that because there will be cross-examination from, I think, page 68
To 106,
to,
maybe a re-examination as well. I think what we need is, have you recently had a look at this document?
indeed, Chairperson, I was accorded an opportunity to do so.
Does it correctly reflect the evidence that you gave at the inquiry chaired by Justice Mohoro last year? That is 2019.
I confirm, Chair.
You confirm that?
Yes.
Okay, thank you.
Amended, Chair. Now, Mr. Mlotshwa, if we can just start, where are you currently employed?
So currently, I am at the Pietermaritzburg Advocates Bar.
And how long have you been there?
I resigned in the NPA end of the year 2015, and at the commencement of the year 2016, I was attached to the pupillage program, which I completed end of 2016. So with effect from 2017, I'm practicing as an advocate at the Pietermaritzburg Constituent Bar.
Before joining the bar, where were you employed?
I would say I've been in the I was in the justice system for almost 16 years, having started as a court interpreter in Durban, appointed as a district court prosecutor in Verulam, 98, 99, I was transferred to Stenger Magistrate Court, 2000, 2001, I was in the regional court Stenger. In the middle of 2001, I was appointed as a state advocate stationed at the Pietermaritzburg Advocates Bar. After 3 years of which will be 2003, I was elevated into the position of a senior state advocate. And then in the year 2008, I was appointed as a deputy director of public prosecutions, KwaZulu Natal. And then in the year 2010 until 2012, I was appointed as the acting director of public prosecutions for the province, KwaZulu Natal.
Can you just tell us for which period were you the acting director of public prosecutions for the province, KwaZulu Natal?
It is effective from the 17th of May 2010 and I think I was recalled, or I stepped down, if I'm not mistaken, on a Friday, the 9th of July 2010, effectively 2 years.
Okay. And who replaced you?
My successor was Advocate Moiponi Noko.
Did she replace you in an acting capacity?
I think so. When I was recalled, she was also appointed to act an acting position that was confirmed permanently, if I'm not mistaken, 2013, 2014.
Okay. Now, if we can just, before we move on to your affidavit, very briefly, what is a Director of Public Prosecutions?
If one looks at the Constitution, firstly, Section 179, it speaks of South Africa.
I'm sorry, what was that question?
What is a Director of Public Prosecutions?
Now we know what a Director of Public Prosecutions is.
Okay.
Let's go to matters that are really important for the witness.
Okay.
Mr. Mlotshwa, you gave evidence already in the inquiry that was chaired by Justice Mokgoro. It would appear that here you would be needing to traverse the same issues. Since we already have a transcript of your evidence in that inquiry, and you have confirmed that this transcript correctly reflects your evidence, the evidence leader will focus on what may be important where it's necessary to get clarification or for you to cover just certain things, because otherwise your evidence was under oath, you were cross-examined, you have signed an affidavit that says this transcript correctly reflects your evidence.
As the chairperson
Okay.
pleases.
So, Mr. Mlotshwa, if we can just briefly deal with what has been termed the Cato Manor, it's been dubbed the Cato Manor Hit Squad prosecution. If we can just deal with that. What was your involvement in that matter?
I became involved when I first received a call from my line manager at the time, Advocate Chiba, informing me that there was a matter that required my consideration. My second involvement was when myself and another fellow colleague, the head of the division, Gauteng South, with the line manager, Advocate Chiba at the time, met in her office, and then a suggestion was made that in the light of the fact that I was the head of the province KZN and the case was emanating from KwaZulu Natal, I will have to sign an indictment to arraign the accused in the matter in the High Court in KZN.
Was the prosecution conducted by prosecutors from your office?
No, it was conducted by prosecutors from other jurisdictions, Northwest, as well as Gauteng South. If I'm not mistaken, the lead prosecutor was from Northwest, Advocate Mayema, and then the other members of the team were from Gauteng South, DPP office.
Do you know why they were not prosecuted by prosecutors from your office?
At that time, I was never given the reason, except that from the discussion that we would have had in the office of my line manager, I could gather that the view was not to involve prosecutors from KZN, as the possibility existed that the investigation may lead to a possible charge of some of the advocates or prosecutors in my decision. That's what I could glean from the discussion that we had in our chambers.
Were prosecutors from the KwaZulu Natal province ever prosecuted in this matter?
To date, no.
Okay. There was also
Were there any allegations that were ever brought to their attention or your attention relating to anybody in your office that are related to the Cato Manor?
I'm not sure if I understand the question, Chairperson.
Were you ever made aware, or were any prosecutors in KZN ever made aware of any allegations against them
No,
relating to the Cato Manor matter?
not at all, Chairperson.
So it's not just that they were not prosecuted, but nobody even ever came to them and said, you are implicated in this way and that way in the Cato Manor
To
matter.
date, as far as I know, that has
Yes.
never happened.
Yes, okay.
Now, if we could just briefly deal with that, if in the province of KwaZulu Natal, if there's a prosecution that's going to be conducted against another prosecution, how would that be dealt with?
Under normal circumstances, if the matter is arising out of a specific division, prosecutors from that division are the ones who are supposed to be handling the prosecution in the matter. But there will be instances where there will be ground-breaking exceptional circumstances that warrant that a prosecutor from another division be brought in to conduct a prosecution. A variety of reasons may exist for that.
The question that I'm trying to get at, did the province of KwaZulu Natal at that stage, the DPP's office, have the capacity to prosecute within its, from prosecutors within the province to prosecute another prosecutor?
In KZN, particularly during my reign, the province, KwaZulu Natal, was handling very huge prosecution projects, some of which you have already made reference to in your bite-sized introductory remarks.
Okay. Let me ask the question this way: was there any reason that you were informed of that would warrant the prosecutors from a different division prosecuting the Cato Manor matter?
Chair, no, except that if one looks at the emails that we made reference earlier on,
You can refer to the emails to refresh your memory.
the chairperson may bear with me.
The email starts at page 7.
Chair, the email that I'm focusing on will be an email that appears on page 9 of Exhibit RR6.
Yes.
If you cast a glance at that email, towards the bottom of that email, the last paragraph reads, "I do not want to step on your toes. I was informed that you agreed and arranged with the Acting National Director of Public Prosecutions for somebody from outside to do the prosecution of this matter. If you have now a change of heart, please indicate so that we may resolve it as soon as possible." That was the first time this was brought to my attention, that somewhere, somehow, there was an allegation that I had made an arrangement for somebody to be brought from outside.
Did you in fact make that arrangement?
Not at all.
Were you ever asked by Ms. Jiba or anybody to agree that the Cato Manor matter be prosecuted by prosecutors from outside KZN?
No,
You were never asked to agree to that.
never.
So to the extent that the writer of that email says that this is what he was told, namely that you had agreed that prosecutors from outside KZN be the ones who would prosecute the Cato Manor. You are saying that's not true.
I saw it first time, and it's a
Yes.
bit generic in the sense that it never particularizes the date, the place where this arrangement would probably have been. It's just generic. There was an arrangement there.
Yes,
I
but of course there might be no need to give those particulars until the writer knows whether you are disputing that you agreed. So if he was told that you had agreed and had no reason to think that's not true, he wouldn't give those particulars. But if you said, no, I don't know what you are talking about, I've never agreed to this, you may say, give me more information, and then maybe he would give you information, or maybe he would say, actually, the person who can give information is so-and-so, who is the one that told me. You understand that?
I do.
Yeah,
Chair.
but you are saying you never agreed you never agreed that the prosecutors for the Cato Manor matter be from outside KZN,
No,
and you were never requested to agree.
no.
Yes, okay.
Did you, in fact, if we just deal with this, with that email, you said the email you were dealing with is at page 9. Who was the email from?
The author will be the person appearing at the bottom, the head of the division, Gauteng South, fellow colleague, Advocate Andrew Chauke.
And on what date was it sent?
It's dated 12 June 2012, in the afternoon, 5:14.
Did you, in fact, did you reply to this email or in writing or telephonically?
Probably, with the leave of the chair, to avoid decontextualizing the emails,
Yes.
if one looks at page 11 of Exhibit RR6,
Yes.
as you lay an eye on that email, you can see from Mamiki Suping. So at the time, that was a lady who was a personal assistant to the head of the prosecution, Gauteng. So that email was following hotly and hardly on the heels of the meeting I had with Chauke and Advocate Chiba, a meeting where she had indicated to me that I'll have to sign an indictment as well as the provisional delegation in the light of the fact that the prosecutors who were going to handle prosecution were not from KZN. So at that meeting, my response had been, I never had a problem of signing an indictment, provided the indictment was going to be accompanied by a memo or a report that will be detailing evidence, my apologies, that will be detailing evidence, how it links each accused individually and the accused as a collective. So as you can see there, it was just an indictment without a memo So as I received that email, it was on the 12th of June 2012 at 1:29. As soon as I received it, I made a call to my colleague to say there seems to be a deviation from the agreement in terms of which when we left at our meeting, we were all consensus ad idem that I was going to receive both the indictment and the memo. But it seems now, I'm not sure if it's the PA who would have committed an error here by sending the indictment without the memo. It's then that I started picking up during our telephonic conversation that that was not going to happen. Then I decided to terminate the call and transmit another email so that I could have a record of what was happening. It's then that you'll be able to see the email that appears on page 9 of Exhibit RR6 at the bottom there. You can see he sent that email. The first email is at 1:29 on 12 June 2012. Then the email that I'm sending to him at the bottom of page 9 from Cyril Mlotshwa, it bears the same subject.
Yes.
Dear Advocate Chauke, our telephonic conversation today refers, kindly furnish me with the prosecutor's memo or report so that I can have a wraparound view of the matter. The report must also have the police station and case numbers so that we can be able to open up the DPP's file. In the normal scheme of things, if the docket is forwarded to the Office of the Director of Public Prosecutions, there ought to be a file opened there. And then that file will contain the docket and everything that relates to that matter. So you can see, when you look at this email closely, that the Office of the Director of Public Prosecutions, KwaZulu Natal, did not have anything in relation to this matter. It was my eloquent and conscious effort to get some info so that we could also open up the file at our office. So it's then that you can see the debate getting heated. A reply to my email at 3:21 on the same page, on page 9.
Yes.
At 5:14 from my colleague.
Yes, I think you can read that email.
Yes. The email reads, Dear Advocate Mlotshwa, who is the prosecutor that you are referring to? I have forwarded to you the indictment which has all the detailed summary by which you ought to be in a position to open up your file, your office file. I also forwarded to you details of the inquest with police case numbers, etc., to which you referred to Advocate Togoma Jogweni. For the record, Togoma Jogweni at the time was the acting Prosecution Services Director at National Office. For reasons that I do not follow and I understand, the indictment with respect gives you the whole view of the matter. You are kindly and fervently requested to please discuss any issues, if any, with me. I really do not see any need for me to give you any report other than what I've forwarded to you already. Please, if I misunderstand you, make me understand. I do not want to play you or undermine your jurisdictional authority in any way whatsoever. There are serious issues of security in this matter, which, if necessary, you'll be briefed about, which are not relevant to you, and I cannot expose such to you at this stage. I've also learned with utter dismay that you have now issued an instruction to the senior prosecutors that all dockets that are with us must be brought to you. What is happening here, my brother? Please, if you have any issue again, talk to me or arrange that we see the acting National Director of Public Prosecutions urgently.
Well, I think it says what is not happening here, my brother.
Yes.
I don't know whether he meant what is happening here, my brother, but what's written is what is not happening here, my brother. I'm mentioning that because I think you read what is happening here, my brother, whereas it's written what is not happening here, my brother. That's the only reason why I'm mentioning it.
As the chairperson
Yes.
pleases. Another issue of concern another issue of concern to me is the delay in you issuing the instruction of the reopening of the inquest in view of the fact that you have been requested to sign the indictment which must be preceded by your decision to reopen the inquest. If this makes you uncomfortable, please indicate so that I may urgently take the matter up with the acting NDPP as well as the minister. That was a bit confusing because if one looks at the lines of reporting within the National Prosecuting Authority, I'm not sure because I'm no longer in the system, the DPP reports to the acting NDPP, and it's the NDPP in terms of the legislation who should report to the minister. So here seems to be suggestive that he has to report to both. I do not want to step on your toes. I was informed that you agreed and arranged with the NDPP for somebody from outside to do the prosecution of this matter. If you have now a change of heart, please indicate so that I may resolve it as soon as possible. Chairperson, it's something that I brought to the attention
And it's from Mr. Andrew Chauke, Director of Public Prosecutions, South Gauteng High Court.
That is the position.
Yes.
Again, if you go back on page 8, that is my response to his email. So, which means in the afternoon after sending an email to him, I left the office late. Upon opening up my emails on the following day, 13 June 2012 at 9:12, that's the email I decided, it's then that I read that email and I decided to respond.
Yes.
Regrettably, Chair, that email is incomplete, my response to him. As you can see, I'm saying to him, Dear Advocate Chauke, I operate from the premise that the mission of the NPA enjoins us to be guided by the Constitution. The last time I cast a glance at the Constitution, I gleaned that its preamble encapsulates that all the rights enshrined in the Constitution have to be respected, protected, and promoted. This includes the right to human dignity, which is affirmed by Section 10 of the same Constitution. I think it is significant that I alert you, or I bring it to your consciousness that as a South African citizen, that this Constitution also renders me a cast iron guarantee to this right. I am acutely aware that as we live in a fast-paced, overstimulated, and I want it quick society, there is always a temptation to arrive at a decision that is based on preconceived ideas. Argumentum ad hominem principle is a well-established principle of law. The caveat is that we should guard against emotions when we engage or interact with each other. If your memory serves you well, you will recall how you threw tantrums at me when you contacted me one morning last month. You leveled serious allegations against me. You did not repeat the same allegations when we met at the NDPP in the office. I maintained my cool through and through. The impression I derive from your behavior is that you nourish a slavish mentality, that you are the only one so fortunate. My apologies. It seems that I was also emotional in that response. And then paragraph 3, Ananias Nin postulates that we do not see things as they are, but we see things as we are. Hence, it is imperative that we make a conclusion that is based on facts, factors, and circumstances. You are posing a question to me. Do I have issues that we must discuss? Supremely significant is the fact that Butler holds the view that words are nothing but just the clothes that the thoughts wear. In 1974, L.F. Hefner postulated that a skillful reader reads the lines, reads between the lines, and reads beyond the lines. Walter Mayer J.A. stated in Art vs. the Blom, 1999 AD, that when we draw inference, the inference that we seek to draw must be from the facts. So 2 pages are missing to that email.
Oh, that's quite a lot. Why are those 2 pages not there?
Chair, these emails come from the information that was provided to us on a hard drive by the Mokgoro inquiry. Only until consulting with Advocate Mlotshwa did we realize that these 2 pages are missing. We are going to endeavor to...
Why was that not seen much earlier? His affidavit was deposed to in December.
Chair, it just wasn't brought to our attention that there was anything missing, because by reading of
but
it...
who was going to bring it to your attention? Because he was going to give evidence in December, isn't it? Or was it November?
In January.
Well, we had the other session, when was it? When Mr. Negati or Manyati testified. When was that?
It was in January. Chair.
Was it in January?
That's correct.
Oh, okay. But by then, they would, what Mr. Mlotshwa was going to give evidence should have been perused and to see if everything was fine. I can't see why that wasn't picked up much earlier.
Chair, it ought to
Both
have
by
been
the investigators, but more importantly by the legal team.
Indeed, Chair. Chair, it ought to have been picked up much earlier. The only reason I can think of is that Mr. Mlotshwa was removed in January, and therefore the file was not perused for the January hearing.
Yes, but who are responsible to make sure everything is ready? It's the legal team, because they are the ones who must lead evidence. If there is anything, that's not ready, they are the ones who must be able to pick it up if the investigators haven't picked it up before it comes here.
Indeed, Chair.
Because how much value can I put on an incomplete email?
Chair,
Because I
what-
don't know what was said in the second page. I don't know what was said in the third page. I don't know if it negates everything that was said in the first page.
Indeed, Chair. Chair, what I will endeavor to do is to ensure that those emails are obtained and perhaps a supplementary affidavit is obtained for the purposes of the Chair. But perhaps this witness could testify if he has memory of what was in that email.
It's unsatisfactory. The legal team should long have picked up if there was an email that was not complete. That should have been attended to obtain whatever pages were missing. And if the position was that those missing pages could not be found, the legal team should have taken a decision whether there was any value in presenting an incomplete email. I don't know whether it would be fair to the witness to ask him to try and remember what the 2 pages that he wrote in 2012 said. Unless he has got the complete email and he has had a look at it recently. Mr. Mlotshwa, do you have a complete email?
Chair, as the incident happened in 2012, I handed these emails to the investigation team in 2015, and I left the system.
That is the investigation team of the Cato Manor matter.
But both teams, the SAPS, the Commissioner of Oaths, I think it's Lieutenant Awe, who appears at the bottom of the email that I deposed to. I gave him those emails. I also gave those emails to the evidence leaders in the Mohoro Commission of Inquiry.
So as of last year, when you testified at the Mohoro inquiry,
They were complete.
this email was complete.
That is the position.
Yes.
That is why when reading the emails, realizing that they were incomplete, the impression I got was that probably when making the copies, someone might have erred and not print out so that's the impression I immediately got when...
Yes, but the legal team should have picked that a long time ago. That's my concern, that the witness is giving evidence and he's referred to an email that is incomplete. I've not been told in advance that there is an incomplete email here.
Indeed, Chair.
I don't understand why the legal team shouldn't have picked that up much earlier and made sure that it was sorted out.
Chair, the only explanation I can give is that, as I've said, perhaps we can endeavor to find it and do a supplementary affidavit.
Yes, of course you appreciate that's not an explanation. That's what you will do to try and control damage. But I really don't understand why. Let's continue with the witness and try and let him cover the important things, and then you can do what needs to be done to rectify this.
I'm indebted, Chair. Are you able to say what the rest of the email contained?
The significant part in the outstanding pages is that I had agreed with the colleague to go and see the acting judge president in the division. He is currently the judge president, Judge Chapi. Because if prosecutors from outside were coming to the division, it was more appropriate for me to introduce him to the judge. He did not do that. So I had raised that in the outstanding pages, that was also my embedded concern, that, look, that was not honored. So the response will be the email 30 June 2012 on page 8. I think he authored that email at 10:32, copying in Jiba as well as Advocate Sistoko Machogweni. In that email, he said, "Dear Advocate Mlotshwa, I've noted your concerns below. I apologize to the extent that you feel I'm not respecting you, and my communication to you was not what you expected. I also apologize for having not told you that I could not travel to KZN due to unforeseen circumstances. I hope this meets your approval, and I've learned my lesson in this regard. I accepted his apology, and then he also gave me another email on page 12, because he had also indicated that the inquest must be reopened. So him saying that that email is also withdrawn, according to the email on page 12.
Let's go back to the practice or system used before a prosecutor from another province can be brought in to prosecute in a matter that is in another province. Is there a policy on this? Are there prescripts that you are aware of that need to be followed? Was there a practice as to how, when that happens and how it is done?
Chair, that is why it was a problem when we met in the office of the then acting director of prosecutions, because what she said to me were two things during that very brief meeting. That one, you'll have to sign the indictment, and then two, you'll have to sign the provisional delegations for those prosecutors. And then at that point, she indicated to me it's a legal opinion she had procured from legal services. She particularized the person from whom she got a legal opinion, Advocate Gerald Nell. I understand he also testified in the Mohoro Commission whether or not he ever administered that opinion. That being a legal conundrum in the sense that if a deputy director is appointed by the minister, is appointed for a specific division, and if one looks meticulously at the members of the team that were forming part of this team that was sent to KZN, the lead prosecutor was Advocate Mayema from Northwest DPP office. He was a deputy DPP and still is a deputy DPP in Northwest, and appointment specifying as such. So if he goes to lead prosecution in KZN, it was going to create a problem. I think another advocate, Matenjwa, Ray Matenjwa, he was also a deputy DPP in the office of the DPP Gauteng South, appointed specifically for Gauteng South, for him to go and prosecute in KZN, that was going to be an issue. And then with the other members, Advocate Yani Mlotshwa. Mlotshwa was a senior advocate, though not appointed by the minister specifically for Gauteng South, but his delegation to execute prosecutorial decisions. That delegation would have been assigned, or would have been signed by the head of the division, my colleague Advocate Chauke. So it's against that background that my line manager at the time, Advocate Jiba, indicated that in terms of the legal opinion that she had procured, I could sign the indictment, I could sign the provisional delegation pending the research and investigation whether or not they can be assigned permanently in that project. So unfortunately, I was recalled in 2012. I'm not sure, because they're still involved, if the case is still in court, as to what is the status of their delegation in the matter.
But that is what happened in the specific case.
Yes.
I'm asking about the general practice or a policy, whether when you were acting DPP in KZN, you were aware of what policies exist within the NPA, or what prescripts, legal prescripts existed that dealt with or governed the situation where a prosecutor would be taken from one province to go and prosecute in another province?
None that I know of.
Yes.
Yes.
Do you have any recollection whether the National Prosecuting Authority Act says anything about such things?
As far as I remember, there was nothing in the act, except that because of the nature of budget, if a prosecutor if the DPP requests assistance, will request assistance from the NDPP, and then the NDPP will get assistance from a specific DPP who has to dispatch the prosecutor to go and assist. It's then that the issue of budget will be discussed, traveling arrangements and so on and so forth, as to which office will have to pick up the tab to pay the bill. So in this one, I was not involved, even with the arrangements, accommodation, traveling. I don't know what happened.
But is your answer that, as far as you know, or rather that you are not aware of any provision in the National Prosecuting Authority Act that specifically deals with getting a prosecutor from one province to go and prosecute in another province?
My answer is affirmative, actually.
And you are not aware that there were any written policies on this?
None that I recall.
Are you aware of, were you aware of any practice that may have been followed over the years?
As I've indicated, Chair, that it will be the DPP, because of some certain considerations, feeling that, look, another division must send a prosecute, but that request will have to go via the NDPP, will make a determination from which division a request can be made to get a prosecutor to go and prosecute in that division.
So your understanding is that indeed there was a practice?
Yes, yes.
And are you saying the practice was that the request had to come from the DPP of the province concerned where the prosecution was to take place?
That is the position.
And that request would be directed to the NDPP?
Will make a determination among the other divisions that are there, where he or she approaches to get assistance.
Well, it ought to be possible to have a situation where a prosecutor comes from another province, because there could be a situation where a sitting DPP has to be prosecuted, and maybe it might be awkward to have one of his or her subordinates prosecuting him. So it ought to be possible to bring in somebody from another province. But you say the only practice you knew is that the DPP would have to make the request to the NDPP.
I concur, Chair. And that was always possible during my time to have somebody from another division to prosecute in another division.
But in regard to this particular matter of Cato Manor, how did it come about that a matter that related to KZN, where you were acting DPP, suddenly got attended to in Gauteng without your knowledge? Because that's what I understand, but you can tell me if I misunderstand something. I get the impression that when you were approached by the acting NDPP and told about the Cato Manor matter, your office as acting DPP in KZN had not been involved in that matter at all at that stage, or do I misunderstand something?
Chair, I think that is the aspect that I also found a bit odd, because in respect of the emails that I made reference to, I indicated that we did not have even the case numbers, the police stations from which those cases will be coming from, except just the indictment. So as we all know, that the practice will be no matter can be enrolled in the High Court, a criminal matter in the High Court, without the DPP file existing. And it is on that basis that once the DPP file has been obtained, then there will be another file in the registrar's office on their part, which will eventually become the judge's file. So with this one, I did not have anything from the day I first became aware of the matter until I was recalled.
So, as I understand your evidence before the inquiry chaired by Justice Mokgoro, you got a call from Advocate Jiba when you were on a trip to Port Shepstone, and that's when you heard for the first time that there was prosecution that was being contemplated relating to the Cato Manor matter. Is that correct?
That is correct,
Yes.
Chair.
As at that time, your office wasn't involved, and as far as you know, no prosecutor was involved in any such matter.
During that telephonic conversation, no indication was made as to who were the accused, as to where in KwaZulu Natal was the matter emanating from, even the date of possible commission of the offenses. I was not given the information. As far as I remember, a call had to be terminated because she indicated that she was at the airport at the time and was gonna call me later. Then I did not receive a call from her. Up until one of the days when I was the chair of the meeting of the managers in KZN and the chief prosecutors and the deputy directors of public prosecutions, me having forgotten to switch off my phone, it rang. As I excused myself from chairing the meeting, seeing who the caller was, it's then that my colleague indicated that he had been instructed to dispatch a team, that is Advocate Chauke, to dispatch a team of prosecutors to KZN. Because I had to go back to the meeting, my reply to him was, we were going to discuss the matter further and thoroughly when we meet again at the DPP's meeting. And indeed, there was a meeting at National Office which took 3 days. First day, it was chaired by Advocate Jiba, if I'm not mistaken. And then the second day, it was discussing the performance assessment of the prosecutors in the country. I think at that meeting, it was a meeting of the DPPs only. And Advocate Jiba was in her chambers. So while that meeting was in progress, it's then that my colleague Advocate Chauke stood up, touched me on my shoulder, and said, let's go and meet Advocate Jiba in her chambers. I left the DPP's meeting following him into Advocate Jiba's office. And indeed, upon entering her office, we exchanged greetings, and then Chauke indicating that, look, we can't discuss much about this case because there are serious security concerns and the possibility that other prosecutors or advocates in KZN may also be possibly linked. And then the line manager, Advocate Jiba, responded that, Simphiwe, by the way, I've got a legal opinion in terms of which you will have to sign the indictment as the head of the province of KwaZulu Natal, and then also sign the provisional delegation for them, the team, to have a delegation to handle prosecution in the province. And my reply to that was very short, in that I will do that, provided in respect of the indictment, it will be accompanied by the report and the memo that will help me to have a helicopter view of what is happening in the matter, as I do not have any information at that stage.
Just as maybe an aside, actually, in order to be comfortable in signing an indictment, wouldn't the position be that not only would you need a prosecutor's memo, I think as the correspondence seems to refer to it, but would you not also need to see the statements of witnesses and so on, or would you be able to sign an indictment without seeing the statements of witnesses?
Chair, as you saw in the emails that I made reference to, that we do not have any file in existence. At that time, I was so desperate to get something so that I could be able to issue an instruction in my office that a docket a file for this matter be opened. It was against that background that at least if I got an indictment as well as the memo or the memorandum, with those two documents, we will be able to open up the file in the DPP's office, because obviously the memo or the report will indicate the police station where the matter or the matters were coming from, case numbers, the investigating officers, and then detail what evidence each witness is saying and the form of evidence contained in the docket, whether it's documentary, eyewitnesses, and so on and so forth. And for me as well, because if, as the head of the division, though I cannot tamper with the decision to prosecute, but I had also to be satisfied that evidence existed to justify the enrollment in the matter.
Yes, but am I right in thinking that you would not be comfortable, or any DPP should not be comfortable signing the indictment without having seen the actual evidence or statements? Am I correct in that? Or is the position that provided you are satisfied on the basis of a memo from another prosecutor who has looked at the evidence, and in his or her memo, he or she details what the evidence is, you may be justified in signing the indictment, even if you yourself have not actually seen the statements or the evidence?
Chair, unfortunately, the outstanding pages of the email will also explain that. Because
Yes.
if you see the email to me asking me, who are you talking about, what report are you talking about, it's then that I try to give an account to him in respect of the report or the memo, saying it is the practice in the NPA, it was the practice then, I do not know currently. For instance, if the National Director of Prosecutions had to issue a certificate for people to be charged with racketeering, with this new racketeering, money laundering, I'll make an example with the projects that I handled, the Amigos case and other projects where there will be racketeering charges. More often than not, the practice will be a memo will be submitted without the copies of dockets themselves. So the memo will be so detailed to such an extent that they put one in a handsome and comfortable space to make a determination as to what is it that is happening in the matter for the NDPP to have confidence to append a signature on the certificate. That's how I appeared to be understanding the situation at the time, that with those two documents, the indictment accompanied by the memo, with that information, I could be in a position to sign the indictment with ease.
So if the prosecutor's memo is sufficiently detailed, that could lead you to being comfortable to sign the indictment, even though you haven't seen the witness statements as such. But if it is not sufficiently detailed, you might then wish to see more, to see the witness statements.
Under normal circumstances, Chair, it's sufficient, because as lawyers will know, in the memo you'll see what facts will be alleged, what facts will be proved, what facts will be disputed, the anticipation of the defense by the accused.
Yes.
What facts will possibly be agreed on when the matter goes to
Yes,
court.
yes.
And then we'll further indicate the oral evidence, documentary evidence, and the shortcomings, if any.
Yeah.
For instance, the witness, it was at night, and so on and so forth. It is so detailed.
So usually it's sufficiently detailed.
That is the position.
Yes, okay.
Chair.
But here, you were being asked to sign an indictment and there was no such prosecutor's memo.
That was the position.
And you had difficulty with that.
I had difficulty with that to such an extent that the way I was viewing the difficulty, I refused to sign the indictment until I was recalled.
Yes. So by the time you were recalled or asked to step down as acting DPP, that issue had not been resolved, namely whether the signing of the indictment, because you were saying, I need the prosecutor's memo, and Mr. Chauke and whoever else were not providing that memo, and Mr. Chauke was saying that having the indictment before you is sufficient. Is that correct?
That is correct.
Yes. What do you make of Mr. Chauke's stance? He was the DPP for South Gauteng himself. So he was except that he was not acting and you were acting, but you were on the same level. You were acting DPP for KZN, he was DPP for South Gauteng. What did you make of his stance that there is no reason for you to want a prosecutor's memo?
Chair, that's the reason why I draw your attention to last sentence above paragraph 3 of my email on
Yes.
page 8.
Yes.
You can see the tone there when I was responding. The impression I derive from your behavior is that you nourish a slavish mentality, that you are the only one so fortunate to be able to see.
So was this something that was shocking to you, that he expected you to sign an indictment without a prosecutor's memo in a matter in which you had not previously been involved?
In fact, Chairperson, before I even made a decision to request a memo, I first went through the indictment myself. As I was going through the indictment, I had that very nagging feeling that the quality of the indictment was not above reproach. So that was the first thing that gave me that sense of discomfort.
Yes, yes.
And then what aggravated that, the non-existence of the memo to explain the indictment.
Yes, yes.
And then in the telephonic conversation, when I request the memo or the report, now I'm being probed or asked, what is it that I'm talking about, as if there is resistance to give me the memo. And then fourthly, any prosecutorial decision, whether you call it office notes or memo, will stay in the file explaining when was that docket received, what evidence was there, what decision was there, in an instance where there is disagreement between the prosecutors. Because the way I understood it then, I don't know now, for my 15 years working in the office of the DPP, you'll find that if the state advocate is making a decision, that decision had to be endorsed by the deputy director of prosecutions as somebody more senior in the entity. I thought that used to serve as a safety valve in an instance where wrong people are prosecuted or people who are supposed to be prosecuted are not prosecuted. So one would always presume that when that indictment was drafted, it should have been on the basis and strength of something that was, so we should have made it easy for my colleague to say, hey, this is what you want. So that also gave me sleepless nights, that if it exists, why am I not
So you had a suspicion that it did not exist?
I was not comfortable at all.
Yeah.
That nagging feeling did
Yes.
not want to divorce me.
Are you able to say, for every matter in which you ever signed an indictment while you were acting DPP, there would have been, or there was, a prosecutor's note? Or would you say there were some where there might not be a prosecutor's memo?
As I indicated, with 15 years of my experience in the DPP office, KZN, all cases where the indictment is signed, there will be an office note in the file. But at the time when I assumed a position as the acting director of Public Prosecutions KwaZulu Natal, I decided to have my own personal parallel process, a parallel process in terms of which I bought myself black books.
Yes.
From day one of my acting until I was recorded,
Yes.
where I would record
Yes.
all my engagements, my interactions,
decisions.
and including my decisions, including the dockets where cases where the police would approach me because I was accessible at the time to discuss the docket, maybe with an inquiry file without a docket, and where I would have given them an advice and the return date upon which we can meet again to discuss the case further. So I also used to record that in the event I'm not in the office and then they call, maybe I'm attending a meeting, I'm able to refresh my memory. So
This idea that you should sign an indictment in a matter without a prosecutor's memo or note was something unheard of as far as you were concerned.
in my experience as a prosecutor, it was something unheard of,
Yes.
unprecedented. let me put it.
Unprecedented.
Yes.
Yes. Okay. Mr. Nicholson, I see we are a few minutes past, quarter past. I think I must take the tea break, and then when we resume, you can then take it from there.
Chair, that's fine, Chair. I don't have many questions.
Or have I taken, have I asked most of the questions you wanted to ask?
You have done so, Chair.
Okay, but during the tea break, you could reflect and see whether there are other matters that haven't been covered that should be covered.
Indeed, Chair.
Okay, we take the tea adjournment. It's nearly 20 past. We'll resume at 25 to 12. We adjourn.
All rise.
Yes, Mr. Nicholson.
Mr. Mlotshwa, we've dealt with the issue. You say that there was no request from your side to have prosecutors from outside of the province prosecute the Cato Manor case.
That is correct.
You've also dealt with the issue that no prosecutor has been charged as one of the reasons put forward for having prosecutors from outside of the province.
That is correct.
Now, just one other issue. At the meeting of the 29th of May 2012, you just made reference to it now. You indicated that one of the other issues that was put forward for having outside prosecutors was that there were some security issues that needed to be taken into account.
Yes.
Were those security issues ever fleshed out?
Unfortunately, I'll have to go back to the outstanding pages of my emails. That is where I raise all those concerns. That even the issue of security, as the head of the division, I ought to have been taken on board. In the outstanding pages of the email, I make reference to a workshop, soccer workshop, SOCA, sexual offenses and child something workshop.
Child abuse.
And child abuse, yes. That workshop was held at OR. So when I attended
OR Tambo Airport.
OR Tambo Airport. So as we were attending that workshop, I stumbled upon a gentleman who was in the security and risk section in the NPA. I think his name was Kenny from the Eastern Cape. So as somebody was in the risk and security section of the NPA, we exchanged greetings, and then he asked if I would be leaving that workshop into one of the bedrooms, of the boardrooms at OR to discuss the issues of security surrounding the Cato Manor matter. It's then that I became aware for the very first time that while we are attending a soccer workshop, there will also be a separate meeting to discuss security issues and consent about KZN. So in the outstanding pages of the email, I also raised that aspect, that look, I felt a bit humiliated as the head of the division that even the issue of security could be discussed without me being involved. And Kenny was not the only one. There was also another advocate Dawood at national office. As I was going into the bathroom, him exiting, he also remarked similarly that I hope you are joining us soon in the meeting to discuss the issue of security about the Cato Manor man. That I just flashed a smile and then left. I did not attend that meeting.
You had not been invited to the meeting?
I had not been informed about the meeting, nor had I been invited to the meeting.
Yes.
And you've also dealt with the issue of the prosecutor's memo, that you have not received the prosecutor's memo, but simply an indictment.
Maybe before that, did you get to know who had convened that meeting that to which you were not invited?
Other than this gentleman Kenny, as well as Advocate Dawood, to date, I do not know who were the attendees in that meeting. I was never favored with the agenda of the meeting, nor the minutes of that meeting. I'm not sure if NPA will be able to help the commission with that.
But you never got more information than what
all.
These two colleagues of yours said?
Not at all.
Yes. Okay.
Outside of this meeting, were you ever briefed about what security issues should be taken into account?
Chair, the email that I referred to on page 9, that is the email from my fellow colleague Advocate Chauke, particularly paragraph number 2, the last sentence. you can see that there he is also penning the issue of security. He says there are serious issues of security in this matter, which, if necessary, you will be briefed about, which are not relevant to you. And I cannot expose such to you at this stage.
Yes. So that's what you knew about allegations of security issues in relation to the Cato Manor matter.
That is the position, Chair.
Yeah.
And as I've said, we've dealt with the issue that you were expected to sign an indictment, although you haven't seen neither the docket nor a prosecutor's memo.
That is the position.
Did you in fact sign that indictment?
Up until I was recalled on the 9th day of December 2012, I had not put my signature on the indictment.
Now, that wraps up that part of the evidence. If I can just briefly deal with the racketeering matter in the Amigos case. Were you involved in drafting of the charge sheet or the indictment for racketeering?
With the Amigos case, maybe to give the context, as I indicated, I was appointed on 17 May 2010. I became aware of it end of May, and as soon after that date, I requested a meeting with the prosecutor at the time. So at that time, no one had been apprehended in the matter. So the prosecutor will be the gentleman who is now with the ICC, Advocate Anton Steinbeck. So when I looked at my notes last night, the first meeting I had with him about the matter was on the 9th of June 2012. Him to come sit down with me in the office and tell me what is it that he is having in that matter. After that, I requested another meeting with Asset Forfeiture Unit, with the SAPS, particularly the investigation team being led by the gentleman, I think Lieutenant Colonel Deploy, as well as the forensic auditing team led by Trevor White. Thereafter, we had a battery of meetings to discuss the matter because I had to assemble a team that was going to substitute Anton Steinbeck, as Anton Steinbeck was about to leave the country for a position at the ICC. And indeed, I ended up assembling the team led by Advocate Dunya, who was and still is a senior state advocate in the office of the DPP KZN. I think the other one was Advocate Nomfundo Spunzi. She is now a regional court magistrate in Mpangeni, and another one is a magistrate in Pietermaritzburg, Mr. Vincent Mkanyana, and one senior advocate, but junior advocate then, Advocate Mtembu.
Okay. Now, evidence has been laid that indeed there was a racketeering certificate signed by the then national, the then NDPP, the one before Chiba. Were you involved in having that racketeering certificate signed?
In fact, in the light of the fact that that matter had reams and reams of documents, plus or minus 220,000, if my memory serves me well, not only were the consultations and meetings continuous between myself and the prosecution team, there were also meetings and consultations held with the then NDPP advocate Menzi Simelane, who would time and again have one of his deputies, Advocate Silas Ramaite, Vili Hofemeyer, because of this aspect of asset forfeiture. Then eventually, after I had satisfied myself that we could enroll the matter in court with the charge of racketeering, it's then that I took my team with the memo to head office to do a presentation before Advocate Menzi Simelane, as well as his deputies and Vili Hofemeyer, And then at that meeting, there was a great deal of unanimity that my team and myself could safely enroll the matter in court. So, which means the national director signed the racketeering certificate, and then as the head of the division KZN, I signed the indictment, which includes, among other things, a charge of racketeering and money laundering.
Can you recall who was at that meeting that you, when you briefed Advocate Menzi Simelane about the possible racketeering charge?
Obviously, it will be myself as the head of the division, and then the prosecuting team, the members that I've aforementioned, and then from the head office, it used to be the National Director of High Prosecutions at the time, Advocate Menzi Simelane, as well as his deputy, Advocate Silas Ramaite, and Advocate Dawood. Because of the fact that the Amigos case in KZN was umbilically connected with another Amigos case in the Northern Cape, a decision was taken that each time we meet at national office to discuss the matter, that the head of that division in Northern Cape, that would be Advocate Ivy Tsenga, be also present with the team that was prosecuting the Amigos case that side. I'm not sure if it was also called the Amigos case, but as far as I remember, it involved one gentleman by the name of John Blogg, and I think the matter was finalized a year or two ago, as well as the investigating team led by Lieutenant Colonel Duploy, and I think the forensic auditor, Trevor White, would also be present.
Okay. Now, evidence has been laid before the Commission by two witnesses, that is Mr. Trevor White and Colonel Duploy, that a meeting was arranged for the 23rd of March 2012 in Durban, where Advocate Mkhwebi stated at the meeting, "I've decided to withdraw charges against Mr. Mike Mbuyakulu, and I want to know what evidence you have against Ms. Nkonyeni." Were you consulted about that?
In relation to that meeting, first and foremost, I did not attend it. I think I had a meeting with the prosecutors in Ladysmith, if not Newcastle. However, at the time when the meeting was held, I do not know how it escaped me. I had not seen that indeed Advocate Mkhwebi had transmitted an email suggesting that the meeting be held. An email wherein I was also copied. So I became aware of the meeting because I received, I think it was an SMS from my line manager at the time, saying, look, there is a problem. It seems our learned colleagues in the media are chasing us. They want to know what happened at that meeting. The journalists have an information that Duploy, as the investigating officer, had confronted Mkhwebi, asking him if he was there to instruct prosecutors to withdraw. So, to cut the long story short, I was not present at that meeting. At a later stage, when going through the emails, it's then that I realized that when Advocate Mkhwebi sent an email that he was coming down to KZN to meet the prosecuting team, he had indeed copied me in respect of that email.
Were you consulted about the withdrawing of those charges?
I think after that...
I'm talking about before the meeting.
It's a bit confusing. I would say after that meeting, there was also another meeting that was held in May 2012. That will be the last meeting, me present, to discuss the Amigos case. Then June, July, then I was recalled. I do not know what happened thereafter.
Is the position that you can't remember whether anybody spoke to you prior to that meeting and said, we are going to withdraw charges against particular accused persons in this matter, or we are contemplating withdrawing charges and we would like to have your input. Is the position that you can't remember whether
Chair,
anybody spoke to you about that?
That did not happen until the last meeting. I'm speaking about that we had to discuss the Amigos case. That would have been on the 23rd or 29th of May.
I think there's reference to 29th of May in your...
Yes.
In your...
That will be the meeting where the chairperson of the meeting, my line manager, Advocate Chiba, would have said, guys, let's sit down and talk. I think her view was there was a great number of accused. Is there no way that we can cut down? And then at that meeting, I think Advocate Silas Ramaide came up with the suggestion that if that were to happen, it's not an easy process. We must first discuss what evidence was there when the initial decision was made to enroll the matter in court, to charge people, so as to be able to make a determination if at this stage something groundbreaking, exceptional would have happened to justify us interfering with the original decision to charge. And then after that discussion, a decision was reached that there appears to be no reason to tamper with the original decision to charge. Then I left that meeting with the prosecuting team on that note. And as far as I remember, the DPP Northern Cape Advocate Ivy Tsenga was also present, but her team from Northern Cape wasn't. But the detectives, Lieutenant Colonel Duploy and the forensic auditor as well, were not present.
Was the meeting of the 29th of May that you're talking about before the meeting that you missed in KZN, attended by Advocate Mkhwebi and Advocate Musing and Colonel Duploy and I think Mr. White, when you had gone to have a meeting with prosecutors in Newcastle?
Yeah,
did it come after that meeting?
I would say the meeting that we had in May was precipitated by the March meeting that I did not attend.
Oh, okay,
Yes.
okay. So at the meeting that you attended in May, was Advocate Mkhwebi there?
When the meeting started, the chairperson had indicated that on that morning he had reported to be unwell. So she indicated that she wasn't sure whether or not Mr. Mkhwebi was going to join us at a later stage.
What about Mr. Mosing? Was he present at that meeting?
No, Mr. Mosing was not present.
Yeah.
But at the initial stages of the meeting, Mkhwebi came in and joined the meeting as well.
Mm-hmm. You mean towards the end of the meeting?
At the initial stages of the meeting.
Or he came
Yes.
after the meeting had started, but
After the meeting
but soon after it had started?
Soon after it had started, at the time when the chairperson was, because when attending that meeting, we had not been favored with the agenda of the meeting and so on and so forth. So the chairperson was still outlining the purpose of the meeting and as to how the meeting was going to progress. So before she could finish off in respect of the introductory remarks, fellow colleague
Mr. Mkhwebi came
Mkhwebi stepped in.
Did the lead prosecutor in that matter, was it Mr. Dunywa in KZN?
It was Advocate Nadile.
Did he attend that meeting?
He was a leader of the prosecuting team, so I came with all members.
So he attended that meeting?
He was present because at the time when we were discussing at the meeting, there was a firm view that the person who does the presentation for all, in terms of identifying the evidence that was there in the original decision, as well as the evidence that was existing at the time of reconsidering, if I may call it that way for lack of better words. So it will be more appropriate if that is being done by Advocate Nadile Dunywa. So he was also present, but my team has changed, if I'm not mistaken. because of promotions and so on and so forth. If I'm not mistaken, Advocate Nomfundo Sipunzi had been appointed to act as a regional court magistrate in the Eastern Cape. So I dropped in new members, but the lead prosecutor was still there, Mr. Dunywa Mkanyana Mtembu, and the head of the SCCU KZN, Advocate Vimbani, Bulelo Vimbani. So they were also present as members of the Amigos prosecuting team.
Now, after the meeting that you missed, which was attended by Advocate Mkhwebe and Advocate Musin in KZN, did you get a briefing as to what transpired in that meeting?
Obviously, after I had received an SMS from my line manager saying, please liaise with the spokesperson. The spokesperson at the time was Advocate Mthunzi Maka, and see how you deal with these questions that are coming.
The media queries.
The media queries. I requested to meet the prosecuting team. It was during that meeting where I was informed that it would appear that the meeting with Mozing and Mkhwebe didn't end on a right note. There were heated exchanges. The investigating officer confronting Mkhwebe about, because it was already in the media, the newspaper had already started writing articles that I was refusing. There was a perception that I was refusing to withdraw, and then I was going to be forced to withdraw certain counts and so on and so forth. So at that meeting, it would appear that Lieutenant Colonel Duploy confronted Mkhwebe exactly with that allegation. Is it true that this is what you intend doing? So that's the report I got.
But were you also told that Mr. Mkhwebe had said they intended to withdrawing charges against, I think, Mr. Mabuyakulu, I think. With regard to either Mr. Mabuyakulu or Ms. Peking Konyeni, as I understand the evidence of Mr. White and Colonel Duploy, in regard to one of them, Mr. Mkhwebe had said a decision has been taken to withdraw charges against this one. Tell me what evidence there is against this other one. I just can't remember whether it's Ms. Konyeni or...
If I can assist,
yes.
It was Mr. Mike Mbuyakulu that Advocate Mkhwebe indicated is withdrawing charges against.
Were you told that that is what had happened at that time?
Chairperson, I might have misunderstood it. The way I understood it was that during that meeting, it was a confrontation between the investigating officer, Lieutenant Colonel Duploy, confronting Mkhwebe with the allegation that the sole purpose why Mkhwebe had requested the meeting is because he wanted to achieve this objective of withdrawing charges against certain accused.
So what you were told was more general and not specific to individuals.
It was more general.
Yeah. Who did you get your report from?
I think I met the prosecuting team.
The whole team?
The whole
yeah, or some of them?
We normally met every Friday.
Yes.
In respect of that project.
Yes, okay.
So I think it was one of those normal Friday meetings with me, with the team, just to get the heads up.
Yes. Now, you said that at the meeting of the 29th of May, which Mr. Mkhwebe attended, you said that the conclusion was that no charges were to be withdrawn. Did I understand you correctly?
That was the unanimous decision.
Which means even Mr. Mkhwebe went along with that decision.
Including Vilihofer, Mayor Silas Ramaite, Ivan Senga, as well as my team.
Yes. Okay, thank you.
Now, just to be clear, the evidence of Colonel Duploy and Mr. Trevor White is that At the commencement of the meeting of the 23rd of March 2012, Advocate Mkhwebi is almost in his introductory remarks, he said, I intend withdrawing charges against Mr. Mike Mbuyekulu, and what evidence do you have about Ms. Nkonyeni? Were you consulted about the withdrawal of the charges against Mr. Mike Mbuyekulu?
No.
Does Advocate Mkhwebi have the authority to withdraw charges, those charges?
My understanding of the situation was that Advocate Mkhwebi was a special director, specialized commercial crime unit at the national office. So a decision to prosecute had been taken by myself as the head of the division, obviously in conjunction with the prosecution team in the matter. So when it comes to a direct answer whether or not he could withdraw, I think if one looks at the nature of the law, that could happen in conjunction with or in consultation with the DPP. But in the light of the fact that the certificate had been signed by the National Director of Public Prosecutions, I think that would have necessitated a thorough, comprehensive presentation to the National Director of Private Prosecutions in terms of demonstrating what is it that would have changed to warrant the interference with the original decision and make the decision that is being made.
Okay. So you've already testified that subsequent to the March 2012 meeting, a meeting on the 29th of May 2012, this issue was rehashed and it was agreed that charges will not be dropped.
That was the unanimous decision.
In August of 2012, charges were withdrawn against Mr. Mike Mbuyekulu and Ms. Nkonyeni. Were you consulted on the decision to withdraw those charges, as well as 4 other people?
When the decision to withdraw charges was made, I had already gone back to my position as a Deputy Director of Public Prosecution, so I was no longer the head of the division. So, but to answer you directly, I was not consulted regarding the withdrawal of the charges.
But the point you make is that there was no need for anyone to consult you at that time because you were no longer acting DPP.
I think so, Chair.
Yeah, you would need to be consulted if you were still acting as the head, isn't it? Or did you remain part of the prosecution team in the case, in which case maybe then you may have needed to be consulted in that capacity, not in the capacity of acting DPP?
The day I stepped down on the 9th, you'll see as I testified, Chair, in the Mokgoro Commission of Inquiry, I had made an undertaking to prepare a handover report for my successor. The following Monday would have been the 12th of July 2012. So during that weekend, I put together the handing over report, including the sensitive files that I had in my custody, the huge projects that I was handling in the matter, including the certificates that I had that my successor had to be aware of. So the following Monday, the 12th, I gave the successor the handover report with all the files that I was handling. That was the last time I knew what was happening in the matters.
Yes, but the question was, if you were no longer acting DPP, would there have been any basis upon which it can be said you should have been consulted after you had stepped down?
In the world of idealism, Chair, ideally, as a person who had been handling the project since 9 June 2010, it is now July 2012, 2 years later. Ordinarily, it would not have been unreasonable for one to expect a person to say, Mlotshwa, you seem to be out fair. with the ins and outs of the project. Maybe to reduce certain things to dimension, how does X, Y happen? So I was completely out of the
Yes.
picture. That is
Yes.
the world of realism.
Yes,
Yeah.
okay.
Okay. Now, in August 2012, when the charges were withdrawn, evidence was laid that you were that the decision was taken by Advocate Noko. Is that correct?
Well, he was no longer there.
I was no longer acting. I was also
Yes.
reading it in the newspapers. I think that will be those articles that are attached to these bundles. I was also following the matter in the
Yes.
newspapers.
No, I
just
think
like-
it's enough that you were no longer there. Yeah.
Okay. Now, when did you formally become aware that you will be removed from your role as acting DPP?
That I was going to be removed, I think from February 2012 until July. Time and again in the newspapers that will crop up that I was battling under pressure. There was a firm view that a need is there for me to be removed. And even when I was attending the funerals during the weekends, some people will approach me and give their sympathies to me that they sympathize with me. This is what an X was about to fall upon my head.
Besides the media reports and the informal conversations that you had, when were you formally advised that your time for DPP is now up? Acting DPP is now up.
If I'm not mistaken, there was a point where my successor, because she was the head of the tax unit, had a meeting with her unit in Durban. Somebody at that meeting, one of her subordinates, did call me to say, "Hi, boy, here the supervisor is saying she will be taking over from you as the DPP." On the basis and strength of that call, I wanted to know with certitude whether or not that was the position. I decided to transmit an email to the then acting CEO in the chairperson, Advocate Karen van Rensbeck. In the email, I was particular. Rumor is flying fast and thick that my days are numbered. I will be removed as the head of the province. Take me into your full confidence. Is this rumor true? She responded in a very terse email, 1 or 2 lines, saying no formal position has been taken in that regard. Consider yourself as being the head of the province. That is why my lower jaw dropped a day or two when I received a call from Advocate Chiba saying, "Can you please come to head office on a Friday?" That was the 9th. So I could then relate what I had had with the invitation for the meeting at national office. So psychologically I was prepared. So indeed, when I went to the headquarters NPA, upon entry in her chambers, she was with Advocate Togoma Chugweni, the acting head prosecution services at the time, and my successor was also there. Other than short exchange of greetings, my line manager, Chiba, told me that Simphiwe, you have to hand over to your successor. A decision had been made that she takes over. She thanked me for the excellent job that I had done in the province. I also, on my own accord, took into my full confidence in terms of assuring them that I was prepared, willing, and ready to put together the handover report so that my successor could have a soft landing on the acting job the following week. Hence, I had to give her the handover report on a Monday, the 12th of July, 2012.
So your evidence is you were formally informed on the 9th of July, 2012, and you did the handing over report on the 12th of July, 2012.
Yes. And this happens in the full context of the fact that initially I was appointed for 6 months. After 6 months, there was a view that I had done well in the province. That 6 months had to be extended by another 6 months. During that time, they were trying to clear up the position of the DPP at the time, Advocate Shamila Batoyi, with the ICC. So after 12 months of my acting, a memo was circulated throughout the country to all the prosecutors saying, up until the situation of Shamila Advocate Shamila Batoyi was cleared up, I would remain the acting head of prosecutions in KZN, which was contradicted by a record, because if that circular was saying up until the situation of Shamila is cleared, and then now I'm recalled before that situation was cleared. Hence, I indicated that there were some colleagues in private practice who were prepared to represent me pro amico in terms of taking both the minister and the president to court in relation to a legitimate expectation, because in these circumstances, the expectation for my permanent appointment was not self-induced, but was induced by my communication with the entity.
Where is that circular? It is not here because I didn't see it here. You are not aware that it is here. I think,
it is not here.
Looking at Mr. Nicholson, he doesn't think it's here. Would you be able to find it?
I will be sending the first appointment of 6 months, the extension of 6 months, the email saying up until the position of the permanent PPP was cleared up, I will remain the permanent. I will remain acting.
Yes. Now, you said that on the 9th of July 2012, when you met with Ms. Jiba and Ms. Noko and Advocate Muchogweni, I think, and Ms. Jiba said you had to hand over to Ms. Noko. Did you say that she thanked you for an excellent job done?
Yes. She told me that I had acquitted myself well as the acting DPP KZN.
Are you sure that that's what she said?
Yes, I can pull.
You're sure about that?
Yes, I am.
Yes. Now, you had been acting in this position for about what?
2 years.
2 years. During that time, would there have been any performance appraisals about how you were performing as acting DPP?
I think, yes, I had succeeded in getting a cash performance bonus.
Yes.
And then, most importantly, my qualifications, Chair. I had a BRIS, LLB, Masters, Human Resource. I think I was busy with my BA honors in philosophy.
Yes.
So
Yes.
everybody in the division, including the judiciary, both in the lower court and the high court, will
Yes.
say the same whenever I stumble upon them, that
Yes.
we are looking forward to your permanent appointment.
Yes.
Yeah.
But now I'm looking at whether there were any performance assessments or appraisals done within the NPA by your superiors, which reflect what they thought about your performance for that time.
Yeah, in
Is
terms
there
of-
something in writing?
I think if one goes to the archives in NPA, in terms of rankings, when I was appointed, I think the division was number 8, subject to corrections, of course. But in the following year, 2011, March or April, I think we were number 2. And then I got a cash performance bonus,
Yes.
monetary reward
For good performance.
For good performance, yes. And most importantly, if you look at the Public Service Act, it stipulates, I haven't checked now, I checked then, It stipulates that if you act in the public service, you cannot be remunerated for a period exceeding 12 years. Meaning, the last time I received a salary for being the acting head of the prosecution was 2011 in May. When I was having all these problems you were seeing in the media, I was not even getting paid for that. I was getting paid for the deputy director of prosecution's position. Of course, with that indication that at any rate, it would appear that you'll be appointed permanently, so don't worry.
So, but I'm asking whether somewhere there should be a document or documents that record how your performance was viewed by your superiors during the time that you were acting DPP.
My understanding is that the CEO at the time was Advocate Clarence van Rensburg. I think that will be the person at the time best placed to have the documentation. I think she.
But are you saying there should be documentation?
There should be a documentation.
Were there performance assessments that were conducted on your performance or on the performance of your office as acting DPP?
The NPA generally, after 3 months, there will be those performance assessment, with the difference being that some are formal, some are informal.
Yes.
But with the last annual performance assessment, it will definitely be formal, and it is on the basis and strength of it that a determination is made whether you deserve a monetary reward for excellent job or not.
So the one in respect of which you were given a cash bonus or payment for good performance, when did that happen? Just before you stepped down or much earlier?
I think that would have happened in 2011.
2011?
Yes.
Would you remember whether it might have been towards the end of 2011?
My understanding then, I don't know now,
Yeah.
the government financial year commences on, I think it's 1st of April to end of March the following year. Yes. So the one that I'm making reference to will be the one that would have wrapped up, I think 2011 March.
March, okay.
But more often than not, you'll find that even though the year ends in March, but the processing of the assessments will be a bit delayed, and then you find that the payments in relation to that cash performance bonuses maybe are paid in May, June, or July. Yes.
But did you say that when you started as acting DPP, in terms of performance, the case at NDPP's office was ranked number 8 out of 9 provinces? Is that what you said?
As far as my memory serves me well,
Yes.
that was the position.
And when you stepped down, do you know where it was ranked?
When I stepped down, I think it was, I'll have to go back to the documents.
Well, if you remember for sure, you can tell us. If you are not sure, you can say you think it was ranked whatever.
I can't remember the position, but it
leave
was
room
no
for-
longer, it was still performing well, but no longer number 2. It's just that I don't have the specifics when I stepped down.
Would it have been around 3 or 4?
I can't put
You
my
can't
name on
remember.
that one.
But had there been a huge improvement in the performance of that office since you took over? Can one say that?
I can safely say that.
Yes. Okay. Is there something that you can find later on and send to the legal team that might reflect what the position was, or is there something that would be difficult to find after so many years?
As I've indicated that I'm no longer in the NPA, the only documentation that I will be able to present here at the commission will be the document explaining my appointment, the first 6 months, the extension of 6 months, and the circular saying up until the position of the permanent DPP is clarified, I will remain the acting head.
Okay. And you say that at the time you were asked to step down, the position relating to Advocate Batoyi had not been finalized, as far as you recall.
As far as I recall, she was still with the ICC
Yes.
at The Hague.
Yes. Okay, all right.
But I think at that time, there was a suggestion that she had taken, I'm not sure whether a contract of
Yes.
5 years or 7 years.
Okay.
So in other words, it had been clarified,
Yes.
warranting or
Yes.
justifying a permanent appointment.
Okay, no, that's fine. And Ms. Noko, what position did she hold at the time you stepped down, before she became acting DPP?
She was one of the deputy directors of Prosecutions, heading the tax unit in Devon.
Yes, okay. Okay, that's fine.
In fact, she was my subordinate reporting to me.
She was your subordinate. Okay. Mr. Nicholson?
Okay. Now, just to wrap up on this point, the issue of Ms. Advocate Noko being appointed, in which office did she work? You say she was your subordinate. In which office did she work?
She was in the tax unit, Devon.
What does the tax unit do?
That will be the unit assigned with the duty and responsibility to prosecute the tax VAT transgressions,
Okay.
offenses.
Do you know how long she was in the NPA?
No.
Are you able to comment on her court experience?
You mean in terms of me seeing her to go to court during the time when she was my subordinate?
Well, can you say anything about her court experience?
Yeah, I don't remember.
Okay.
Did Ms. Jiba give you any particular reason why you were being asked to step down at the time that she asked you to step down, particularly in the light of the circular that you talked about?
Chair, at the time when she indicated that I had to hand over, at that time, personally, I wasn't okay because of stress. As you could see in the newspapers that they were reporting that I was battling under pressure. That
Yeah.
was indeed the position, to such an extent that in June 2012, I was supposed to be running my third or fourth comrade marathon. The family doctor had made a recommendation that I shouldn't run because of my state of emotional state. So to me, it came as a great relief. The only thing I could do to her was to thank her on behalf of the NPA for having accorded me an opportunity to get an experience and explore whatever ideas I had that I could convert into deliverables within the entity.
It sounds like you wanted to get out of the position. Is that true or not really?
No.
You did not want to get out of the position.
All I'm trying to say is that the circumstances were so unbearable
Yes.
to such an extent that I was expecting anything. Not that I wanted to
Get out of
leave,
the position.
To get out of the position.
What was bringing about this? What was causing this stress that you are talking about? Because I assume it was work-related. Obviously, I'm not interested in personal matters.
Yeah, it was quite a number of professional reasons. Among others, when I took over as the head of the division, Risk and Security Services conducted an investigation. And when the investigation was conducted, it was then that the investigation was able to unearth that my life and that of my family was not safe.
Were in danger.
So we're in danger. On the basis and strength of that, I was afforded and I was given security, bodyguards and security at my house. So as people were talking about all these things, me being under pressure, on the side, I was also having a problem, an allegation that in the first place, I never deserved security. And then there were certain allegations, people saying I'm abusing security. Myself and my kids and my family were inseparable. People starting to question how come when they go to school, I'm there with security and so on and so forth. So, and then when I stepped down, when I left the office, I used to arrive early in the morning and leave late, 7 o'clock, 6 o'clock. As we were leaving with the bodyguards received a call prior to my calling. They received a call, I think, a few meters out of my office, saying I must be dumped on the road. So, because I had worked with them for a number of months, after receiving that call, they told me that, hey, look, the call we're receiving is that we need to dump you here on the road.
This was now on the
That is 2012.
day
No,
after,
around March.
long
April.
before you stepped down.
A month or two before I
Yeah.
stepped down, I had been, the security had been removed from me. So as they received that call, in the car they told me that they were receiving an instruction to dump you here on the road. What do you? Then I told them that, guys, I don't give a damn even if I lose a job. With you, I feel sorry for you guys. Make a decision. If you will not be fired by proceeding to take me home, because we are now 7 kilometers away from my house, if your job is safe, we can proceed and you can drop me off at home. Or if you drop me here, I can call the wife at home to come and pick me up. I'll tell her where I am. And then they said, it was the situation was very sour in the car. They said, no, we'll rather drop you off at home. We will see what they do at work. So few minutes later, they also received a call, bodyguards, from the security guards at home, because there were stable guards who were guarding my house. So those security guards were calling the bodyguards, asking if they received any call, because they had also received a call saying they must leave my house. So it was a cocktail.
It was a number of factors.
A cumulative effect of
Yeah.
which, so I had to be hospitalized for piles and so on and so forth. And the doctors were saying they could attribute it to nothing else but a
Stress.
stressful environment I was finding myself in. So when I received that call to go there, so in
You
the
were-
family,
that was the
everybody
context
saying,
why you were
accept
relieved.
whatever. Yes,
Yeah.
yes.
Okay, all right.
Do I understand that very abruptly the guards were removed from you?
That was the position.
And who provided these protectors and the security guards at your home?
As I indicated, there were threats at my house. There were threats in the office. People calling, not indicating who they were, buzzing at the gate at home and so on and so forth. Reported to crime intelligence. Crime intelligence conducted their own investigation. I think I also have those reports. They conducted their own investigation. After the investigation, they came back saying the situation warrants that I be assigned with security. So on the basis and strength of that, I had to be given security, the bodyguards, and then at home, the security guards. I would say it was the Department of Justice in conjunction with NPA.
Okay. And who gave the instruction to very abruptly remove those the security measures?
The way I was, the condition I was in, mentally and emotionally at the time, including my family, I did not even bother to ask, because I could feel that at the time I was swimming against the tidal wave.
Yeah.
But it may have been somebody from either the NPA or the Department of Justice.
To date, I
Well, he
never
doesn't know.
even asked
Yeah.
the bodyguards nor the security guards.
Okay. You also mentioned that you referred to the media reports that said that you were buckling under pressure. The pressure you were buckling under, is it related to the normal work that you were doing in the DPP's office?
Well, first ask whether he was buckling under pressure in the first place.
Are those reports correct?
You know, with media, sometimes it's difficult if they have not given you the foundation upon which they are making the allegation. But to cut the long story short, the prosecutorial job it comes with a lot of pressure as well. The head of the prosecution is West.
There certainly was pressure, is that correct?
If you look at the projects that were in the division,
Yes, there was pressure. But are you able to say you were able to handle the pressure, or are you saying that you were not able to handle the pressure?
I will say I was able to handle the pressure.
Yes,
That's
okay.
good. If I wasn't, I would have voluntarily came
Resigned.
in and resigned.
So the issues that led you to be hospitalized, the issues that led you to miss the comrades marathon, was that normal work pressure?
Not that I missed the comment. I said I ran it against my medical practitioner's advice. Their view was I shouldn't, but I did. So I think it was work-related.
Was it normal work pressure? Is the question I want to get.
I would say it was an abnormal pressure.
Did you say abnormal pressure?
I would say it was abnormal if it culminates in one being seen by the doctor.
Okay. Now, just to wrap up your evidence, after spending nearly all your adult life as a career prosecutor and rising to the ranks of senior deputy DPP, and in fact, acting at DPP, why did you join the bar?
In fact, when I picked up all these problems in 2012,
Well, I guess the more appropriate question is, why did you leave the NPA?
Why did you leave the NPA and
Where you went might be neither here nor there, but why did you leave the NPA after so many years?
I thought I had done everything in the NPA.
Yes,
No,
okay.
from the rank
It was
of
for
the court
career
interpreter.
reasons. It was for career purposes.
That is the position.
Yeah, okay.
Okay. And are you able to, given the fact, the issue that we dealt with in the Cato Manor prosecution, the way prosecutors were being imposed into your province, given the way charges were withdrawn after you had left, can we draw any conclusions from you no longer acting as a DPP? Can we draw any conclusions from that?
Maybe don't put it like that. Are you able to tell us why you were asked to step down?
Chair, I would think that falls peculiarly within the personal knowledge of the people who recalled me.
You yourself are not able to say why you were not told, and you haven't analyzed what happened and come to any conclusion as to why you were asked to step down.
After I had stepped down, I was also looking at the speculations, including the timing of the withdrawals and so on and so forth, that possibly my recalling could be attributed to that.
Could be attributed to?
That the main reason why I was recalled was to make certain decisions.
Yes, okay, all right. Thank you.
Chair, those are my questions for this witness.
Thank you, Mr. Mlotshwa, for coming to give evidence. We appreciate it, but for now you are excused. If there is a need for us to call you back, we'll call you back. But thank you very much, you are excused.
Thank you, Chair.
We are going to adjourn for the day. There will be no hearing tomorrow. There will be no hearing next week as well. But as things stand, it is intended that the hearings should resume on Wednesday, the week after next week. The venue for the hearings will no longer be this venue beyond the end of February. The plans are that the hearings will be held in the old chamber of the Johannesburg municipality. Arrangements are being finalized, but as I understand it, it's just the formalities. In substance, agreement has been reached that the commission for the rest of the year, its sittings will be in the old chamber at the Johannesburg municipality. So, but in due course, there will be a media statement once all the formalities have been finalized. We adjourn.
All rise.